Good morning, everybody. Welcome, welcome. My name is Dana Sparks, and I am the uh, instructor of today's class, which is the 2026 Georgia Association of Realtors Contract Dissection class. I am also the broker of Maximum One Greater Atlanta and the director of the school, which is offering this course for CE credit. So I just tell you that I'm a broker because this is a contracts class. So I am what they call a non-competing broker, meaning I don't actually help the public buy and sell anymore. I've been licensed for 30 years, so I have been there, done that, completely know what you guys are going through. I don't even see every contract. We have a completely separate compliance broker who sees every contract. I just see the ones that have um, issues or something interesting. I do all our 10-day letters, things like that. So again, I'm just giving you a little bit of background regarding my interaction with contracts because this is a contracts class. So I'm going to dive in. I have there are handouts available. You don't need them for the class. I have sent you where you can find them online, and I just attached a copy. I'm going to attach a copy one more time where this is a PDF, and I'm going to put it in the chat, and you can download it. Okay, I don't want that. You can download it right from the chat. This is a package of all the handouts. So I'm going to share my screen and we will get started.
Dana, quick question. Do we need to put our name and info in the chat?
Yes, I am going to cover that, but yes, you need your name, your license number, your email address, and your phone number in the chat. And you are going to have to do that 3 times. Now, at the beginning, when we come back from break, and uh, when right before you leave. So I am not teaching from a PowerPoint. I am teaching from the contracts themselves. Notice to students, I'm going to make this a little bit bigger so everybody can see it. There we go. This is the school. The Real Estate Academy of America, GREC school number 6915, is offering this course for CE credit. 2026 GAR Contract Dissection, GREC course 79633. This is a virtual remote broadcast of an approved in-class course, 3 hours in duration. This does count for salesperson CE credit and broker CE credit. So those of you with a broker's license that have to fulfill the new license law on getting 18 hours of broker categorized CE, this does count as 3 hours towards that broker CE new license law requirement if you hold a broker's license. Regardless if you're qualifying or managing broker, that's if your license is broker rather than salesperson. I'm the instructor, no homework, no exam. So this is how we do attendance that our school was approved for. All students must be on time and present for the remote virtual broadcast instructions in order to receive credit. Roll call and documentation of students' real estate license number will be conducted via the chat function at the beginning, at the end of the session, and after all breaks. So 3 times. You guys, if you've already done it, you don't need to enter it again. You just need to do it when you first come on, when you come back from break, and before you leave. Additionally, I will ask questions. I ask a lot of rhetorical questions, but I will also ask a question and I will prompt you to put your answer in the chat. We have a lot of people on this class. So in the interest of time, even if I have already given the answer, go ahead and put your answer in the chat as a matter of us being able to record attendance, that you are actually online paying attention and you didn't just turn on your computer and walk away for 3 hours. Students may only attend one virtual course at a time. If GREC determines that a student has virtually attended simultaneous courses or courses with overlapping times, GREC will not give CE credit for either course. You may only receive credit for a specific course number, not topic, but number, once every 12 months. If you have already received credit for this course within the last 12 months, you are invited to attend but will not receive additional credit. There is no recruiting. If so, let me know, GREC know, or the coordinator of our school, who is Heidi Kelly. There is her contact information. I do have the chat open so I can see your questions. We will do questions via the chat also. I see someone's having problems signing in. I can't resend the link. You just have to go back to your previous invitation or the monthly email that our school sends out every month. The link is on there again. Again, I am teaching class, so I cannot reach out to that person. So you can email Heidi or call Heidi if you jot down this email address, ce@realestateacademyofamerica.com, and that phone number, and you can send that to that person. All right. We're going to dive in. Now, the thing I need to let you know is this is not a contracts 101 class. This is I teach at a more in-depth level, so I am not going to go through how to fill in the blanks. We have a lot to cover. You guys, this class, I could teach hours and hours and hours just on the purchase and sale agreement. Today's class, my goal is to cover the purchase and sale agreement, the financing exhibits, the closing attorney is holder of earnest money, termination, and reinstatement. We're going to spend a lot of time on the purchase and sale, but again, not a 101 fill in the blanks. I am going to teach at a little bit, not higher level, that's important. That's probably the wrong adjective, but I am going to teach at some interesting things about the purchase and sale agreement that you may not be aware of. So, let me put it this way, that I will remind you of. I'm sure you were aware of it. I will remind you of. My goals for teaching any class, for those of you, I do see we have a lot of people on here. For teaching any class is number one, that the time goes by very quickly. Number two is that you really, at the end of the class, you will have enjoyed it and have learned something to enhance your business. And the 3-hour CE is just bonus, that you're like, oh my gosh, that was way better than I was expecting. I was expecting just a contracts class. I needed the broker CE, so here I am. And most importantly, that I honor God and that I am a reflection of His goodness and His glory, so that in turn, you may all be a blessing with your real estate license for others. So with that, I'm going to dive in. Again, I'm going to put it one more time in here where you can get the handouts online. And let me attach the package, the entire package, which has all of these documents I'm going to cover today with my underlines, with my notes, all of that good information. It is in the chat where you can click on that and download it. So let's dive in. Okay. The purchase and sale agreement, GAR F201 2026 version. Again, you know you need to fill in the property address and you need a legal description, especially in Georgia. A property address is not enough, especially in Metro Georgia. How many Peachtree roads are there? more than one. You want to make sure that the buyer is buying what the buyer intends to buy and the seller is selling what the seller intends to sell. You absolutely need a legal description. If you mark this box that it's attached, what you are attaching is the warranty deed, or the legal description actually written out, meets and bounds, or however it is written out. If it is a condominium, condominium refers to ownership, not style. A lot of the public thinks that condominium refers to attached housing that's one level. We oftentimes refer to a condo as that, but condominium, as you know, as a real estate agent, refers to ownership, not style. That the owner owns the inside and has shared ownership with others for the outside. If it is a condominium, you do need to attach the F204 condominium resale purchase and sale exhibit that has a different legal description for a condo rather than a fee simple property. And deed book would be the warranty deed book and page. Here is where you can get the information: the warranty deed, online tax records, gsccca.org, closing attorney. Do not fill out do not fill out number 4 if you do not have all of that information. If all you have is land lot and district, don't fill it out. That is not a complete legal description and will not help the property. And then you fill in the purchase price, seller's monetary contribution towards, I'm going to make this a little bit smaller, towards a buyer's closing costs at closing. That used to be called just closing costs, but it's anything that anything that to offset a buyer's cash to close, as long as the lender approves it. Closing date. Put in a specific date, y'all. Stop putting on or before. Do not put on or before March 26, 2026. That does not indicate a meeting of the minds and is not necessarily enforceable. You need a specific date, and if the parties want to change it, you would change it via amendment. And then for possession, and GAR gives us a little hint: if the seller is staying in the property after closing, because they will no longer own the property, you need to attach the temporary occupancy agreement. And it is only if a seller is staying in there for 60 days or less than 60 days. If it's more than 60 days, you need an outright lease, and the buyer is now an investor, not an owner occupant. So you need to make sure that you use the temporary occupancy agreement. It is just temporary occupancy, not a full-blown lease. And then you indicate the closing law firm and their phone number. Holder of the earnest money. This is intended to be one of the brokers. However, nowadays there are a lot of buyers and sellers that choose to have the closing attorney as the holder. If buyer and seller negotiate for the closing attorney to be the holder of the earnest money, tell me where on the contract the closing attorney signs the purchase and sale agreement, agreeing to be the holder of the earnest money and fulfill all the responsibilities as holder. Tell me where in the purchase and sale agreement the closing attorney agrees to do that. Yes, that is a trick question, but you guys caught on to my trick. There is nowhere in the purchase and sale agreement in and of itself that the closing attorney signs. That is why GAR a few years ago came up with a form for the closing attorney to agree to fulfill all the responsibilities of the holder of the earnest money. Now, when you, as a licensee, you are an affiliated licensee affiliated with your broker. When a broker brings you into their brokerage, one of the things that they allow you to do is if that broker is named in a purchase and sale agreement to be the holder of the earnest money, your signature by affiliation means that the holder agrees to fulfill all the responsibilities of the holder of with respect to the earnest money. A closing attorney doesn't sign it. So if you have a closing attorney that is going to be the holder of the earnest money, and there are a lot of responsibilities there, then the F510, and we'll cover this, this is where the buyer and seller agree to that. The F511 is not part of the contract. It is a standalone agreement where the closing attorney says, yes, I agree to fulfill all those responsibilities. And then you fill in the amount of earnest money and when it is due, the amount of the earnest money. When you put this A as of the offer date, that means the holder already has that earnest money in their possession and or on deposit. If it is so many days within the binding agreement date, that means the buyer is not required to send the earnest money to the holder until the number of days from the binding agreement date. Both agents, buyer side agent and seller side agent, have a responsibility to ask the holder, did you receive the earnest money? Did you deposit the earnest money? Did you receive the earnest money? Did you deposit the earnest money? This is not just a buyer's agent responsibility. I'll tell you why. If there's an issue, nothing's an issue until there's an issue. But if there's an issue and the buyer defaults and the seller wants that earnest money, and you as the seller's agent never checked with the holder to see if they had it, and the holder for whatever reason did not fulfill their responsibility by sending notice that they didn't have it, and the seller wants that money to offset their time off the market, who do you think the seller's going to be upset with? That the holder doesn't have it, is not going to give it to them. You, their agent. So both buyer side and listing side agents have a responsibility to check with the holder. And then due diligence, you fill in the number of days from the binding agreement date that the seller gives the buyer the right to terminate for any or no reason. Option payment, I have not seen an option payment. Maybe 2 contracts in the extremely fast market we were in a couple years ago, and I'm going to cover that a little bit more. Lead-based paint, if the property was built prior to 78, or if anything in the property was painted prior to 78, you need a lead-based paint disclosure.
Must be.
And then agency, you need to complete buyer's brokerage, and you put in the name of the brokerage, is working with the buyer as a client, customer, dual agent, designated agent, and same with the seller's broker. You only fill in the name of the agent working on each side if it is a designated agency situation. If it's not a designated agency situation, you guys, you have the name of the agent on the signature page and the time limit of the offer and then the initials. So you guys know how to fill in the blanks. Let me cover some more interesting or just some things that you will, that your clients might or customers might have questions about. So the purchase and sale agreement, your contract and all the exhibits and all the amendments are nothing more than a set of instructions to all parties what they have to do for a property to go for ownership and title from one person to another person. This is what the buyer has to do. This is what the seller has to do. This is what the closing attorney has to do. This is what everybody has to do. So what type of deed? The buyer might say, well, what type of deed am I getting? They're getting limited warranty deed. Limited warranty deed means the seller warrants the title only for their time of ownership. And it is limited warranty deed subject to these things: zoning, utility, all the easements that come with it. Other than, and if I have it underlined in purple, that means that is a new addition for 2026. And that had not been in the contract package prior to 2026. So for 2026, GAR added wall, fence, mailbox. So limited warranty deed as of the binding agreement date with the easements recorded, but it does not include those. Why? Those are movable. Declarations, if there are any covenants, conditions, and restrictions, title objections raised by the buyer prior to closing, and any leases. I'm going to spend a little bit of time here. Buyer's agents, if there is somebody living in that property that your buyer writes an offer on and goes under contract on, and it is not the owner, i.e., it's a tenant, there is a lease there. Your buyer is buying the property subject to that lease. They cannot terminate the lease. And if for whatever reason that tenant is not out, then that first of all, if the lease doesn't expire, just because a seller sells a property, if there's a lease in there, a change of ownership does not terminate a lease. And if a lease has been terminated and that tenant stays in there as a tenant at sufferance, that's not a reason to not close. Now the buyer will need to start the eviction process with the writ of dispossessory in court, so forth and so on. So leases and other encumbrances specified in the lease. Buyer agrees to assume seller's responsibilities in any leases specified in this agreement and the closing sale of the property. Buyer shall not terminate such leases. So this is what you should be thinking, you buyer's agents, if there's a lease. Number one, perhaps you need a special stipulation that the closing is contingent upon the tenant the property being vacant. If it is not that way, then, and the tenant is in there, then another thing to consider is you want to address in your contract the transfer of the security deposit from the current owner, the seller, to the buyer if that tenant is not out. So that if the buyer now has to evict that tenant and there is damage, there is a security deposit, because if you don't address that in the contract, that security deposit is with the other owner. There is other verbiage in there in the lease, but just to let you guys know, and you might be working with some investors who want that tenant to stay in there. And then examination, this means that the buyer has the right to examine the title and obtain a survey. We know the buyer is not the actual one examining the title, but this says if there is an objection to the title, which we will know from communication from the closing attorney who does the title exam, that the buyer needs to raise an objection prior to closing. So agent-to-agent communication does not count. Your buyer will need to send a notice to the seller that there's an objection on title if it is an objection that prevents them from conveying good and marketable title. Okay, my gosh, what on earth is good and marketable title? Well, again, let's look to the instructions. Good and marketable title is defined. And what that means is title which the title insurance company licensed to do business in Georgia will insure at its regular rates, subject only to standard exceptions. So good and marketable title does not necessarily mean insurable. It has to do with how much the premium cost is to get that insurance policy. And purchase price is paid in US dollars in a method of delivery acceptable by the closing attorney. And then closing costs. So GAR, again, I believe it was either last year or in 2024, they changed the label of this pile of money from closing costs to seller's monetary contribution towards the buyer's costs at closing. Again, there's two things to remember here. Number one, this pile of money that a seller agrees to contribute to a buyer can be used for any costs the buyer needs, any cash to close the buyer needs. However, it must be approved by the lender. And so that's spelled out here. Pay any cost or expense buyer related to this transaction. But I'm emphasizing this point that the buyer's mortgage lender may or may not allow. So this can be used towards a buyer's commission obligations to their broker, and that's spelled out here. It could be used towards a buyer's homeowner's insurance. It could be used towards a buyer's HOA fees. It could be used towards a buyer's buy down. It could be used towards any cash to close, just a general buyer credit that a buyer needs, but the lender must approve it. There are certain loans, depending on the type of loan and the type of down payment the buyer's putting in, there are certain percentages that are capped where the buyer can only accept up to a certain amount of outside contributions. That means not only from the seller, but any commission rebate you guys are giving your buyers. So if you are giving a commission rebate to your buyer, wherever you have that in writing, in your buyer brokerage agreement and or in the contract, you need to qualify that and make sure to include in your verbiage that it is contingent upon lender approval. Because guess what? It's a license law violation to give a buyer or a seller money back, part of your commission back after closing. So if you're giving a percentage or a flat fee back to a buyer or a seller, and you've done an awesome job at negotiating, and the seller has agreed to also contribute towards a buyer's cash to close, and so part of your money can't go back because it'll exceed what the lender allows, that buyer's going to still want that money after closing, but you can't do it because you'll be violating license law. That's why, again, wherever it is that you have in writing that you're giving any type of commission rebate back to a party, to a buyer, you need to say contingent upon lender approval. And any unused amount that the seller has agreed to contribute towards a buyer goes back to the seller, and that's spelled out there. The seller also will have additional items that they have to pay for at closing. And here's what a buyer is required to pay for at closing. These are buyer side costs: transfer tax, title and tax records, closing attorney costs to do their job, prepare the deeds, and all other fees, costs, charges associated to close this transaction. This proration section means that any property taxes, or if the closing attorney just collects an estimate, if the tax bill isn't out yet, or if the current seller has appealed their property taxes and they haven't heard back from the county, when any of those things are decided and the actual tax bill comes back, this is the buyer and seller saying, we agree to settle this ourselves and divvy up the amount of either money coming back if the property taxes were too high, or money owed if the property taxes were too low, based on our portion of the taxes as of day of closing. So again, this is saying buyer and seller agree outside of closing between themselves to take care of that. This also says that if there is a tax appeal, if the owner has applied for appealed their taxes with the county and it has not been resolved as of closing, any pending tax appeal for the year which the property is sold shall be deemed assigned to the buyer. Now, let's move on to the closing and possession date. The 8-day unilateral right to extend closing. This was changed pretty dramatically in 2026. I'm not going to read this paragraph to you, but I have it outlined what all of those changes are. Another thing I need to tell you about this. This is not Georgia law. This is only a GAR contract provision. I'm going to skip to the end just because in my notes, I have this all spelled out for you where it's easier to see than reading that paragraph, which is very confusing. So hang on. I know I'm making you dizzy. Hang on, bear with me. Here we go. Regarding the party's right to extend the contract unilaterally for 8 days, meaning you only need one party signature. Last year, they put in an 8 p.m. deadline that the party sending the notice to extend the contract for 8 days unilaterally had to send that notice prior to 8 p.m. day of closing. They've taken that out. Now the time frame goes, either party may send it through 11:59 p.m. last day of closing. Now, the buyer may only use it for mortgage lender delays not caused by the buyer. The seller may only use it for title delays that may not be resolved by paying money or prevent the seller from conveying good and marketable title, or an attorney delay, as long as that attorney delay is not caused by the seller. The buyer may also use it for an attorney delay not caused by the buyer. So either party can use it if there's an attorney delay. But once the attorney delay has been used, like, the other side can't use it. The buyer can only use it if there's a mortgage delay not caused by them. The seller can only use it if there is a seller delay, as long as it's not something like a lien where they can just pay it off and convey good and marketable title. That means this is a huge change from last year. That means the 8-day unilateral right to extend a contract may now be used twice, once per buyer and once per seller. Again, the caveat is that if it has been used by either party for an attorney delay not caused by the party, it may not be used again for an attorney delay. What's the same is the party exercising the extension must do so by notice, and it has to be for one of those specific allowable reasons. Last year, before this change, anybody could use it for anything. So, for example, if there was a title delay and that was communicated via the closing attorney, the buyer's like, I want this house. The buyer, prior to this year, could have used the 8-day unilateral extension to hold that seller in contract for 8 days for the attorney to work out that title issue. Now, if it's a title issue, if the seller doesn't use it, the buyer can't use it strictly for that. So anyway, big changes to the 8-day unilateral extension. And again, it is not law. It is just a Georgia Association of Realtors contract provision. What it can't be used for is something like, well, the movers are delayed, or seller has a contract on another house and their contract for the house they're buying is extended. May not use that. You can always extend the closing date via amendment where they both agree. This is just a unilateral extension. And then at the closing, this says the seller shall give the buyer all the keys, door openers, fobs, access cards, codes, instructions, how to contact a third party. Because this is in here, y'all need to think about if the seller is staying in the property for a temporary amount of time after closing, the seller is probably going to need a way to still get in and out of the house. So this is saying the seller shall provide the buyer with all keys, door openers, fobs. So I'm just, again, the purpose of today's class is to point out to you what's in the contract so that you know and can handle and answer your clients' questions accordingly. Devices and fixtures. Our houses nowadays have so many gadgets that GAR has now addressed this in the purchase and sale agreement regarding everything that is controlled electronically, and perhaps the owner can open and close the garage door via an app on their phone, or lock or unlock the door, or turn on and off the air conditioning or the heat, things like that. And perhaps you've given guests various codes, gate codes, door lock codes, usernames, and passwords. This paragraph addresses how you deal with that in a contract so that the seller terminates their rights to all of that third-party access. And there could be a third party, like if there's an alarm system, there's a third party monitoring system that has access. So this is how all of that is addressed. And any cost of transferring third party support to any of these devices, it is and confirmation that the sellers and or third parties administrative access is terminated is the responsibility of the buyer. So buyer's agents, you need to make sure that your buyers look at all of these issues during their due diligence period. For example, are there any, is the HVAC system leased or owned? Or because a lot of times there's all sorts of solar panels, all kinds of things that are leased rather than owned. This is something your buyers need to check out during due diligence, because if they don't want the cost of that, that would be the time to terminate. And then the closing attorney, this paragraph, you guys, this defines what an actual closing is. So first thing, it says buyer shall have the right to select the closing attorney. Why is that? Who does the closing attorney represent in a contract? Type in the chat. Who does a closing attorney represent? All right. Good job. I had buyer, nobody, lender. Yes, if there is a loan, the closing attorney represents the lender. That's why the buyer has the right to select the closing attorney. Now, if there is not a loan, my earring fell out. If there's not a loan, the closing attorney represents the buyer. And all of this is spelled out here. I have some of it underlined for you. The closing attorney shall represent the mortgage lender. In transactions where the buyer does not obtain mortgage financing, the closing attorney shall represent the buyer. However, y'all, your buyers all of a sudden think they have legal representation if there's a dispute, right? That's what they think. There's a dispute, and they're going to now go to the closing attorney and say, you defend me to that seller because you represent me. The contract says you represent me. No, no, no. The closing attorney, no, it's a cash deal. Closing attorney shall represent the buyer, but not if there is a dispute. Here is what the closing attorney represents the buyer in: preparing the closing documents, clearing title to the satisfaction of the title insurance company, conducting the closing, dispersing the funds, recording the deeds, issuing an owner's title insurance policy, and that's it. Other than those services specifically listed above, nothing herein shall obligate the closing attorney to perform other legal services, including but not limited to certifying or warranting title of the property for the buyer, except pursuant. So nothing else. The closing attorney doesn't represent the buyer for anything else except pursuant to a separate engagement agreement, meaning if that buyer wants legal representation for a dispute, they have to hire an attorney. Now, in Georgia, the closing attorney is required to have in writing which party they represent. And again, it's for purposes of basically doing the paperwork and doing their job as closing attorney. So not only is that, so that's law, and that's why it's in the GAR contract. The closing attorneys will also have one of the million gazillions of documents that they have all the parties sign is a disclosure who they represent. So just be careful, because there are some situations where a closing attorney already has a representation agreement with a seller. If that seller has hired them to represent them, then there are situations, and a lot of time that's with new construction, There are situations where a seller, the closing attorney represents a seller, and that is disclosed. So again, most of the time that is with, well, not most of the time, a lot of the times that would be with new construction. All right, let's talk about earnest money. And I'm sorry, the closing gets later. What I thought I was going to say about what defines a closing is a little bit later. Holder of the earnest money. You guys, this is why it's really important. Who's holding the closing of the earnest money? There's a lot of responsibilities. So first thing is the earnest money has to be in a form, a method of payment acceptable to the holder. So you guys as agents, especially you buyer's agents, whomever the holder is going to be, typically you put in your broker or the closing attorney. Okay, one quick question. When they're representing the sellers, why the buyer is paying for their services for new construction closings? Well, the closing attorney, if there's a lender, they still represent the lender. So, and just because a new construction subdivision gives concessions using various vendors, that doesn't mean they necessarily represent the seller. So that would be a question to specifically ask a closing attorney in that situation that you are in. Okay, good question. All right, the buyer's agents, whomever is going to be the holder of the earnest money, whether that be your broker or the closing attorney, first thing you need to do is you need to find out what form of payment do they accept. Do they accept personal checks? Do they require, for example, certified funds over a certain amount? Do they require wires over a certain amount? Do they accept ACH transfers? Do they accept electronic transfers like Venmo or Cash App? These are questions that you need to know. It is not specified in the contract anymore, the type, the form of the earnest money, but you need to convey that information to the buyer. And a lot of times, if a holder does accept a personal check, how long does a holder hold that before being able to act upon it? Many brokers and closing attorneys will accept a personal check up to $5,000, but they'll hold it for 10 banking days. That's a long time if a buyer terminates short before that, where they're not going to get their earnest money back. So again, method of payment acceptable to the holder. And the holder has the right to charge the buyer for any cost associated with receiving earnest money. A holder might, if there's a cost for a holder to accept a wire transfer, they might charge the buyer for that. You need to find that out. And that would be separate from the earnest money. In 2026, GAR added this sentence that the fact that the holder may represent one of the parties in the transaction as a client or is working with such party as a customer is acknowledged by the parties and shall not be the basis for the holder not performing any of its duties hereunder, including but not limited to dispersing the earnest money based upon reasonable interpretation of this agreement, meaning the 10-day letter. If the broker is the holder of the earnest money, most of the time they have a client relationship with one of the parties, typically the buyer, could be the seller. A lot of times you listing agents are doing a really good job. If you have full confidence and faith in your broker, that you want your broker to hold that earnest money. What this is saying is just because I have a client relationship with one of the parties does not mean I do not have the ability to now put on my neutral hat and interpret the contract and do a 10-day letter based on the contract, not on the party that I represent. And all parties acknowledge that. So that's one of the responsibilities of the holder. The other one is to deposit the money. Well, when do we have to deposit it? The holder has 5 banking days after the binding agreement date or the date 5 banking days when the money is actually received to make that deposit. And then the rest of this paragraph talks about, well, what happens if the buyer never sends the earnest money or the bank doesn't accept the earnest money? Well, this paragraph spells all that out. the first thing that has to happen is the holder has to give notice to the buyer and the seller, not agents. You guys, you are not the holder. So a lot of times, for whatever reason, you will discover through agent to agent communication that the buyer never sent the money, or they sent the money, but it bounced from the bank, or the bank didn't honor it for whatever reason. You as an agent cannot send the email. You as the listing agent can't send an email to the buyer's agent and say the earnest money wasn't honored. The holder has to do that. You guys have to know who the holder is. That's why I'm saying both of y'all need to check. Did you receive the earnest money? Did you deposit the earnest money? And if not, y'all need to get that holder to do their job and send the notice. And in 2026, you brokers here, there is a brand new GAR form. As a broker, it's one of my favorite new forms, F528. It is the holder's notice to send to the buyer and the seller that the earnest money was either never received or not honored by the bank. That date of that notice kicks off all these time frames. Then the buyer's in default. The buyer has 3 banking days to cure. If they don't cure, the seller then has 7 days, calendar days, to terminate this agreement. If the seller does not terminate the agreement, you go to closing with no earnest money in the deal. Then more about earnest money. And let me just show you in your package, I have a handout for you. This is good for brokers to cover with your agents. This is good for newly licensees, and this is really good to remind yourself. Points of practice. I have 3 pages of points of practice for earnest money, time frames to send it, both agents following up, finding out what the policies are. Do not commingle funds. That's a license law violation. If earnest money is over $10,000, the holder's required to fill. You guys, we have to fill out an IRS form unless it's a wire. So all of this information, if the buyers or if you buyer's agents, you're telling the buyers to send it in to the broker, the holder. Well, what address did they use? What name did they put on the envelope? On the check for the earnest money, do they have the property address? So I've got a bunch of tips and tricks on here for you guys regarding earnest money. And that, again, 3 pages of that. And this is in your handout package. And now back to the purchase and sale. Who's entitled to the earnest money? Our purchase and sale agreement tells us that. And basically, all things being wonderful, it gets credited towards a buyer's cash to close at closing. If not, if the parties never go under contract, the buyer's entitled to it back. If it terminates due to the default of the seller, this is when it's entitled. This is not when they get it back, because this is just laying the groundwork for who is entitled to it when. If it terminates, if there's a default, if there's a separate agreement or at closing. That's not the actual disbursement of it. Regarding the actual disbursement of it, that is spelled out here. So this is how, let me go through here. If there's so let's say I'm the holder of the earnest money. It's in my account. It's in my trust account. How do I get it out of my trust account and disperse it to one of the parties? Well, if I receive a court order or an order from an arbitrator, I have to act on that and I disperse it based on a court order. Or if the parties never, here's the second one, a subsequent written agreement by the buyer and the seller. That's a termination and release agreement. And I'm going to cover that a little bit later in the class. I have to have buyer and seller agreeing in writing to disperse who I'm supposed to give give the money to. If I don't have their agreement, I get to do what we call a 10-day letter. And basically, this says the holder may disperse upon a reasonable interpretation of the agreement, but I have to give the party. So buyer and seller, you do a TNR, it doesn't close. Buyer and seller don't agree on the release of the earnest money. One of the things I can do as the holder, oh, are you guys not seeing me? Can you hear me?
Yes.
Okay, you can hear me. You just can't see. Can you see my screen?
Yeah,
I
I
can
can
see
see
your
your screen. You're
screen.
just frozen.
Oh, okay. Probably with my mouth open, right?
Of course.
Of course. Crazy. All right.
Yes, I can hear,
As,
just not see.
all right. As long as you can hear me and see the form, that's okay. I don't know how to fix the camera. And I don't want to turn the camera off because, oh, maybe I can do that. Oh, well, I'm not going to mess with it because I don't want you, because the important thing is the contract, not me. So, all right, we'll continue on. Sorry about me being with my mouth open, but all right. So I go through the contract and I say, okay, what happened? What did the buyer and seller agree to based on the contract and what they agreed to? And this up here, who's entitled to it based on that? I say, I am going to disperse the earnest money to buyer or seller based on these reasons. I can't disperse it immediately. I, as the holder, have to wait 10 days for the other party not getting the money to make an objection. The objection has to be based on something they agreed to in the contract. So for example, it could be uh that there's an amendment out there I never got a copy of or something like that. But that's why we call it the 10-day letter, because I have to wait 10 days after giving my notice who I'm going to send it to. The other thing I can do is I can say, woo, this is way too much money. And this is very legally complicated. There are so many contract issues going on here. I am a broker. I'm not an attorney. So I am going to send it to court and let a judge decide. And that's called an interpleader action. Now, the other thing that it says in here is if the holder does end up giving the earnest money to the seller as liquidated damages for the buyer's default, if the amount is over $600, I can request the seller give me fill out a W-9 before giving them the money, meaning they're going to get a 1099 at the end of the year and have to pay taxes on that. Based on the big beautiful bill that passed, the 1099s are now being issued if the amount of money is over $2,000, not $600. So I am 99% sure that GAR will change this where it says $600 to $200 up to $2,000 in the mid-year revision. And then this talk about the interpleader action. If I have to send it to court, I get to take my court costs and fees out of the earnest money, and the loser has to pay the winner's attorney's fees. One more thing about here, if it is complicated and you get a notice from the holder saying, I'm sending it to court as an interpleader action, I can't decide. One of the things you have to understand, and this is all spelled out in here too, I can't divvy up the money. If I, as the holder, look at the contract and like, well, seller, you messed up a little bit here. You didn't do what you said you were going to do. Buyer, you said you didn't do what you said you were going to do here. I can't split the money. I have to treat the money as one big pile. The judge can split the money, or a buyer and seller on a termination and release agreement can choose to divvy up the money themselves. I promise you guys, well, I don't promise, but it is most of the times in the buyer and seller's best interest. If you get a note, if you find out, if you give a notice that the holder is going to interplead it into a court, You need to go back to your both sides and say, look, you guys need to negotiate and divvy up this money. Nobody wants to be involved in a court case. Nobody wants a civil judgment lobbied against them. And there are additional costs that come out of that earnest money. So that's just a thing to keep in mind. And then there is a hold harmless statement that the buyer and seller agree that if it is a 10-day letter and the holder disperses the earnest money, as long as it's not outright fraud, they agree they cannot sue the holder. While we're here, there's a lot of hold harmless language throughout the GAR purchase and sale agreement and exhibits and amendments, basically saying the party can't sue the other party for whatever reason. Just because that's in the contract doesn't mean they can't sue. Anybody can sue anybody for anything. What that language in the contract does when you have them signing this contract, it means that the party's lawyer can argue this, that they agreed to that in the contract. But just because it says somebody can't sue, anybody can sue. I'm just letting you know that you can't sue. Well, I just did. This is just, again, groundwork for an attorney to make an argument in front of a judge. All right, let's move on a little bit to inspection and due diligence. Every property is sold as is. And what as is means, there's a lot of people that think, oh, the seller's selling it as is, I can't have any inspections done. No, 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 no. As is just means the seller is at least initially saying, I do not intend to do any repairs to this property. You can have it inspected. As a matter of fact, you're supposed to have it inspected. It is your responsibility, buyer, to have it inspected. But I'm not doing any repairs. What you see is what you get. As is, meaning you accept it with all faults, any and all faults. However, sellers, you listing agents, you need to tell your sellers, even if they are selling it as is, Georgia law requires them to disclose any material, latent material defects, meaning a defect of the property that they have knowledge of that a buyer cannot determine themselves upon reasonable inspection. You as an agent, if you have knowledge of a latent material defect, you too are required by your license, by license law, to disclose that, even if the seller tells you not to. But so that's what that's talking about. And it says buyer has the right to carefully inspect the property, even if a seller is selling it as is. Then it says buyer, you need to check it out and see if it's a meth house, any sex offenders on the sex offender list, so forth and so on. Buyer's responsibility to inspect the neighborhood, not you as an agent, buyer. And buyer's inspection rights through closing. How would you disclose? There is a notice form that I would disclose that through the GAR notice form. 816 is the GAR notice. Buyer's inspection rights through closing. Why? Well, if the buyer and seller did negotiate for any repairs, even if they didn't, the buyer has the right to go check out the property and do a walkthrough prior to closing. And then this indemnification obligations. Again, buyer agrees to hold seller and brokers harmless from all claims, injuries, and damages that they might or any of their invited guests might experience for them doing their inspection and doing their due diligence. Now let's talk about due diligence. What is due diligence? If the property is being sold subject to due diligence, that means that you create a mini option contract. The seller gives the buyer the option to terminate the contract and get their earnest money back for any or no reason, as long as they send notice of termination before the expiration of the due diligence period. This is only a termination right for a buyer, not a seller. And a buyer doesn't have to give the reason. There are all sorts of things a buyer needs to do during that due diligence period to make the determination, am I going to continue on with this, Or am I going to stop the process now, get my earnest money back, and go find another property? They're going to have the property physically inspected, inspect the roof, check for termites, have a survey done, check for zoning, check the school districts, use Google Earth to make sure that there's not a nuclear power plant behind the cedar cypress trees that you can't see. Check to see what the traffic patterns are like. Do I have to make a left turn at rush hour out of my subdivision where there's no light and I'm going to be 45 minutes late to work every day because I can't cross traffic? Do I like it? Am I getting a change in job? Is the lender going to give me my money? Are there solar panels that are leased that I'm going to have to pay for the lease? What's going on with the homeowners association? What are some fees that I might not be privy to? Is this in a floodplain? Am I going to have to pay additional flood insurance? What's the age of the roof? Am I going to be able to get my roof insured? These are all things that a buyer is going to want to check out themselves during the due diligence. Hey, what are the utility bills? To make the determination, am I going to terminate and get my earnest money back or go through with it? Now, during this time, a buyer can say, hey, seller, I'm still trying to make my decision if I'm going to go through with this or not. There's some things I found with the property, and I'm asking if you will take care of these things. It needs a new roof. Will you put a new roof on it? Or there's some rotten wood around the windows. Will you replace and repaint the wood? Or there's reverse polarity in the GFCI outlets. Will you fix those? And a seller can say, yeah, I'll do all that stuff. Or a seller can say, nope, not touching it. Or a seller can say, well, I'll do this, this, and this, but not this, this, and that. The buyer's going to write all that stuff up on the amendment to address concerns with the property. And I should have included that, but I didn't. So 2 things about that. Number 1, an outstanding amendment to address concerns with the property, or if you're negotiating, does not extend the due diligence period. The due diligence deadline is a drop dead deadline. So if the buyer's asking the seller to do these things and the seller hasn't decided yet, and you're coming to the end of your due diligence period, if they are make it or break it things, for example, new roof, a buyer's like, I can't afford a new roof. Your buyer needs to go ahead and just terminate and protect their earnest money. Because the seller trying to decide, once you get past that hard time frame of the due diligence period, if the seller has not agreed to do any of that stuff, your buyer has just bought it as is. And the seller is under no obligation to do any of those repair items, regardless of agent to agent communication. That's number 1. Number 2, the amendment to address concerns is the only amendment. I'm taking notes myself, you guys. I'm going to make all these notes on this amendment, and I'll pop it up in the school website where you can download this. The amendment to address concerns is the only amendment that has a time limit, a built-in time limit. And what it says is, and Faye, I do not have a tip sheet on due diligence, but I'll create one, and I'll also pop that up in where you guys can get the handouts in the school website. So I've just made notes on that. Let me get back to the amendment to address concerns. It has verbiage in there pre-printed that says that amendment needs to become effective prior to the end of due diligence. I also have a YouTube channel, Real Estate Made Crystal Clear, and I just did a video on this, so you guys can see all that there. But regardless, what does all that mean? Okay, let me tell you what that means. That means that, and it says if it is not made effective prior to the end of due diligence, it is of no force and effect. What that means, you agents, if you are representing a buyer and they write an amendment to address concerns, and you're coming to the end of your due diligence period, it's not make it or break it items. Your buyer still wants the house. There are just some things they really didn't want to have to pay for. For example, replacing the rotten wood around the windows and repainting, or repairing the polarity in the outlets, or something like that. You have an amendment out to the seller. The seller has not signed it. Through communication with the other agent, you're getting the impression that the seller is going to go ahead and take care of that stuff, but they haven't signed it. You go past the due diligence period. And now a seller signs it, and you get that signed amendment to address concerns back after the end of due diligence. Guess what? That's not part of the contract. Even if the seller said they were going to do it, if you don't get it back before the end of due diligence, seller is not required to do anything they said they would. You would then have to turn around and write up all that stuff on a general amendment. Very important. The amendment to address concerns is the only amendment with a built-in time frame. And yes, there was a one of the comments. The only way to extend a due diligence period is by agreement. There is an amendment to extend due diligence period that the buyer and seller can agree on. But short of that, there's no automatic extensions of the due diligence, except for the state of emergency, which I'll cover in a minute. And a question about, can they amend the timeframes? You can amend the timeframes if you do so by agreement. So it would have to be initially in a special stipulation in your purchase and sale agreement, or in an amendment agreeing to put in a time limit, either an hour time or a day time on due diligence. But all of that has to be agreed to between both parties. And then here is, again, I've already talked about the seller's duty to disclose latent material defects, any warranties transfers subject to the buyer's acceptance and at buyer's expense. If there's a warranty that a seller has paid for, and let's say they're making monthly payments on that, it does transfer, but the buyer would have to pay for it. And then repairs. All agreed upon repairs and replacements shall be performed in a good and workmanlike manner prior to closing. Just briefly, and I do have, let me show you guys this. The repairs in and of themselves do not survive a closing. And what does that mean? That means repairs. Here we go. Let me show you guys this, and I'll type this up. Okay, this is what I've just said about repairs. Oh, man. Here we go. All the contract says is repairs are being completed in a good and workmanlike manner prior to closing. That's it. It does not survive closing. If you negotiate for repairs, a seller's obligation to complete repairs does not automatically survive closing and is not a contractual reason for a buyer to terminate. So what do? If at all possible, don't negotiate for the actual repair work to be done, but negotiate for these issues financially. Either increase the seller's contribution to the buyer's cost at closing, decrease the sale price, or this is a great way to do it. Negotiate for a general buyer credit at closing. And here's the special stipulation you would use, or here's what you would write up in an amendment. At close, well, two ways. At closing, seller to give buyer a credit of X amount of dollars. Again, that must be approved by the lender. And if not approved, money may not exchange hands. Here is a better way. At closing, from seller's proceeds, seller to pay, and you put in the vendor of buyer's choice. Seller to pay ABC Roofing Company, X amount of dollars, or seller to pay somebody's painting service $3,000, whatever. This is a fabulous way to address repairs. Number one, it does not impact outside contributions to a buyer, so the lender doesn't have any say in it because it's not money going from a seller to a buyer. The check at closing comes from the seller's money, and the closing attorney writes a check to the vendor of the buyer's choice for that money. Closing attorney gives the buyer that check, and then the buyer can schedule the work at their own schedule and have all the receipts and warranties. If, however, the parties do end up having to negotiate in the contract for actual repair work, you need to also include termination rights for the buyer if the seller doesn't perform the repairs. It's not an automatic termination with refund of earnest money if the seller doesn't do all the repairs in an amendment. Also, I suggest you put a time frame rather than day of closing to give the buyer the right to go and check on the repairs and talk about receipts and warranties transferred to the buyer. Another way to handle it is with escrow money, where money gets escrowed. The seller escrows money with the holder for repairs to be completed after closing. And I suggest you don't write that up yourself, because you're not going to have all the ins and outs and what ifs and could be's and all that. Use the GAR 513 escrow agreement, where it has all of that written out by an attorney. All right. I'll type this up and have that for you available in the handouts as well. All right, let's go back. And let's move on to lead-based paint. Ooh, I got to talk faster. We have a lot to cover, and we're still here. That's why I'm telling you guys, there is so much here that could be hours and hours just on the purchase and sale. Lead-based paint, you guys know prior to 78, you need the lead-based paint exhibit GAR F316, including anything like an antique mantelpiece, reclaimed barnwood, things like that, or you would need the lead-based paint disclosure. Buyer has the right to do a separate from due diligence or any other time frames, right to do a 10-day assessment of lead in the paint and terminate on that, get their earnest money back. Buyer is required to get the EPA pamphlet on lead-based paint in the house. You can find that in GAR or from EPA.gov. And you agents also have to sign the F316, the lead-based paint disclosure. Listing agent absolutely has to sign it, that you've told the seller their duties, their legal obligations with respect to potential lead-based paint, and that you agents have informed the seller of their obligations. Listing agent has to. Buyer's agent in 2026 on the lead-based paint exhibit, you have to initial that as well if you are getting compensated by the seller side, either from the seller directly or from the seller's agent. And you have to inform the seller of their obligations. Brokerage relationships, this is the paragraph that describes no agency relationship, dual agency, designated agency. One of the things, this is Georgia law, or this is this is our real estate Beretta law. But a lot of you guys, when you're talking to your public, you say, I've got a fiduciary responsibility. My fiduciary responsibility. Y'all, as a real estate agent, you do not have a fiduciary responsibility to your buyers or your seller clients. That is not the relationship you have as a real estate agent to a client. That does not define our client relationship. So what does? It is spelled out in Beretta. Per Beretta. I have it here for you guys as a reminder. Agents in Georgia act as intermediaries with defined responsibilities, not traditional fiduciary responsibilities. Those defined responsibilities are described in the contract and the brokerage agreement. For example, I just mentioned it. If you have knowledge of a latent material defect,
It's been a long
and the seller says, don't tell, sorry, you have to tell. that's just one example of not being a fiduciary. You can't keep the seller's secrets, and you are not responsible for their money. That's another part of being a fiduciary. So again, in 2026, Georgia GAR Forms Committee just helped us by writing that out. That's not new. It's just basically what is in Beretta. And then compensation of brokers, this describes that, and that does survive closing. It is required for closing. And then this disclaimer paragraph. This paragraph is so protective of you as an agent and your broker, and it is informing the buyer and the seller what their responsibilities are and what your responsibilities are. And all that I have underlined in purple are 2026 editions. And a lot of that isn't necessarily anything new. Some of that is just more for simplicity of how to talk about it, basically. But it says buyer and seller have not relied upon any promises, statements, or representations of the brokers other than what is included in this agreement, amendment, pre-showing compensation agreement. That means anything that's written, and what GAR added for 26 is promises and statements, meaning your conversations with your buyers and sellers and your agent emails to your buyers and sellers. Buyer and seller, y'all, you do not rely on what I say as a real estate agent. I am a real estate agent. I am, and it says and amendments. I, as a broker, and you, as my affiliated licensee, have no duty to determine even the identities. There's so much identity fraud right now. We don't have the duty to determine the identities or the legitimate in all this whole laundry list of items. I don't have a duty to inspect for termites, hazardous conditions, check on repairs, no duty to advise you on any matters relating to the property which could have been revealed with inspections, septic tank, water tests, moisture, meth lab, lead-based paint. If something is important to you, buyer, with respect to the property, construction, soil, blah, 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 zoning, you have the duty to consult an expert in that area. Seller, I'm not the one telling you if this wasn't a good investment or bad and what you're going to net out of the property. You also have the duty to check for maps, laws, regulations, zoning, so forth and so on. Buyer and seller acknowledge broker doesn't perform or have any expertise in any of the matters handled by professionals referenced above, or in evaluating or interpreting any of the tests or reports or inspections you get. So that is really important to protect you and to make sure the buyers and sellers understand your role as a real estate agent, not an expert in one of those areas. Now, time limit of the offer. A lot of agents mistakenly believe that this is a time frame for a response. This has nothing to do with a response. This is the time frame that the offer is open for acceptance. So, you fill that out at the very bottom of paragraph A, which I showed you. And that means the terms of this offer as presented by the buyer, and there is a counter offer, there's a time limit on counter offer, is only open for acceptance through that time. So for example, let's say you write an offer and you say, this offer is open for acceptance until 6 p.m. on February 25th. That means you only have a binding agreement if the party, so in my example, buyer sending the seller an offer, time limit 6 p.m. tomorrow, February 25th, 2026. If that means the seller would need to sign it with no changes and send notice of acceptance back before 6 p.m. tomorrow, and then you have a binding agreement. If the seller signs it and sends it back after 6 p.m. tomorrow night, you do not have a binding agreement. Because the offer was taken off the table. It is no longer up for acceptance. If the seller is going to make a counter offer and change any of the terms in the offer, the time limit doesn't matter because they're not accepting it as presented. So if you sellers, you listing agents, if your seller is going to make a counter offer, cares about the time limit? It's of no consequence to the contract. A seller can make a counter offer before the time limit, after the time limit, 20 days, not 20 days. Well, yeah, they could. 2 days, 3 days. A counter offer totally negates the time limit. It is only with no changes. It is not a time that the seller is to respond with an accepted contract or with a counter. And then paragraph C covers a ton of other information. That's why they call it other terms and conditions. So this is where the majority of that other paragraphs A and B really are more pertinent to the buyer and the seller. The rest of this obviously is pertinent to the buyer or the seller, but this is more instructions for you as the agent. So I'm going to cover what's in here and what you guys need to be aware of. I told you guys purchase and sale is a lot. We're going to go, I believe we're going to go till 11:15 and then we'll take a break and then we'll knock out the rest for the last hour. So notices. Basically, you guys, this is so important. And those of you who have been in my classes before have repeatedly heard me harp that agent to agent communication has no bearing on the contract. Why? Because the contract tells me so. Notices must be in writing. So you're thinking, well, agent to agent, that's by email, that's writing. Legible. Okay, email's legible. Here's the kicker. Signed by the party giving the notice. That is when you are communicating with respect to the contract and the agreements between your public people, you need to do it in writing and they need to sign it. You are not a party to the contract, only the buyers and the sellers. So that's important. And then here's how notice can be done. But here's something that I need to tell you. Most of us are doing business via email. Notice is deemed to have been okay, I'm sorry, it's down in the second part. This is when notice is delivered. In the case of electronically, meaning email, the date and time the written notice is sent is when it is deemed received, even if it's not open. This is really important, you buyer's agents and you listing agents, both of y'all, both sides of any transaction. If, let's say, a buyer is terminating prior to the end of due diligence and they send their notice of termination, you buyer's agents, you have it signed, you send it to the listing agent at 11:58 p.m. on the last day of due diligence. Well, that listing agent's asleep. And they don't get it until the next day, which is after the expiration of due diligence. Guess what? The buyer still terminated prior to the end of due diligence and is entitled to the earnest money back because they sent it. The contract just tells us it is deemed to have been received based on the date and time the notice is sent, even if it's not opened by the recipient. Now, one other key thing here, sent to an email address set forth herein. On the signature page of the purchase and sale agreement, y'all need to see what is auto-populating for your email address. If it is an email address that perhaps was given to you by your broker, but you don't use that, you need to go in there and change it. Because if, let's say that the contract auto-populates with my email address, dana@maximumonerealty.com. But in practice, I use my branded email address, Dana@thehousesoldname.com. And so my agent to agent communication has been through Dana@thehousesoldname.com. But what's printed on the contract is my maximum one email address. If the buyer's agent sends their termination at 11:58 p.m., last day of due diligence, they have to send it to what's printed on the contract, my maximum one email address. They will then have complied with the contract. So, couple points. You guys need to check the email addresses that pre-print on your contract and change it, or do a notice, agent to agent notice, changing your email address for purposes of notice. And you as an agent or brokers are authorized to accept notice for the clients if you are representing that party as a client. If you are working with a public person as a customer, notice has to go to the customer. What does that mean? So if you are working with a buyer or a seller and they have not signed a brokerage agreement, by default, they are a customer. Notice has to be sent to their email address. What does that mean? That means, I'm going to show you what that means. Here, at the bottom of this page, if any of these say that the broker is working with the public person as a customer, the first thing you do is you go to the very last page. And here, where it says buyer or seller, whichever one was customer, you need to make sure you have their email address. Why? Because of what I'm talking about now. For purposes of notice, you have to send notice to the customer themselves. Now, as a courtesy, that customer has still chosen that broker to work with, so you still are going to send it to the agent. But in terms of protecting earnest money, for example, you need to send it to that email address of the customer. Now, if you are working with your public person as a client, meaning they have signed a brokerage agreement, you can get notice, your broker can get notice, or staff at your office can receive notice. The only time you can't is if it is a dual agency situation or a designated agency situation. Then it has to go to that party as well, or to the agent. All that's spelled out there. Now, what happens if one of the parties defaults? Well, it tells us right here what happens if the remedies of the seller. So if the buyer defaults, the seller's sole remedy is the earnest money. That's it. Now you go down here though, and it says, unless the seller has otherwise waived their right to terminate due to the buyer's failure to pay earnest money, seller may, after the termination, sue the buyer for any portion of the earnest money that was not paid or returned as insufficient funds. That means we have had some buyers that never sent the earnest money and then terminated by default. And they think, oh, well, my money's safe. No, it's not safe. The seller has the right to sue the buyer for that earnest money if the buyer defaulted. So I just want you to know that was added, I believe it was last year. It was either last year or 2024. Now, what happens if a seller defaults? Well, that is a little bit different situation. If the seller defaults, then the buyer has a couple of options. The buyer can either seek specific performance, meaning they go to court and they have a judge decide whether the seller has to go through with the contract. It's not a court case for money. It is a court case for pursuing the contract. If they're going to do that, they file the lawsuit, which puts a notice on title, so the seller prevents the seller from selling to anyone else. But You buyer's agents, if your buyer's going to sue the seller for what's called specific performance, their earnest money stays in the deal. Because if a judge rules the seller has to go through with it, then earnest money is part of the contract. Or the buyer can terminate this agreement and then they would get their earnest money back. The other thing that's here, buyer may pursue any other remedy available at law. So if a seller defaults, a buyer has much more legal leverage to pursue a seller for defaulting, whereas if a buyer defaults, the seller can only get earnest money. Brokers, if either party defaults, as a broker, we have the right to pursue the defaulting party for the commission we would have earned had the transaction closed. So you agents working with parties that are defaulting and think, oh, well, it's just the earnest money, no big deal. No, it is a big deal because the brokers can also pursue them for the full compensation. And then attorney's fees. This fancy language here, non-prevailing party, that means loser in a court case. Prevailing party means winner in a court case. Meaning, if it goes to court for any reason or arbitration, the winner most likely will have to pay the loser will most likely have to pay the winner's court costs and attorney's fees. Risk of damage to property. If the property is substantially destroyed, this says at closing, the property should be in substantially same condition at closing as it was as of offer date. If it is destroyed or substantially destroyed, and that's typically by a weather event or vandalism, then here's what they can do. They can either terminate or they can, the seller can sign over insurance rights, or the seller can get the property back up to the condition and then they have to close. That's all spelled out there. Here's what happens if the property has been condemned. This is consent to share non-public information. Okay, delays caused by emergencies. This was brand new last year, and this was used for the first time this year. What this says, if at any point after binding agreement date, the governor of Georgia declares a state of emergency for the county in which the property is located, all unexpired time deadlines herein, including but not limited to closing date, shall automatically extend for the number of days the emergency exists in that county, but not more than 8 days. Nothing herein shall prevent the parties by mutual agreement from proceeding forward without extending the deadlines. No deadline shall be extended if this agreement becomes a binding agreement during a state of emergency. You guys, this was a really interesting issue that we encountered in January because the governor of Georgia, Governor Kemp, declared 2 back-to-back states of emergency for the entire state. One was from January 22nd through January 29th. And the second one was from January 30th to February 6th. And there was a lot of confusion. And there are a lot of contracts that are still in extensions due to those 2 states of emergency. So in essence, what that means is that closings and all other time frames have been extended for 16 days with nothing in writing. The only thing you put in writing is if they agree to not extend. And a couple of things that we learned during these 2 states of emergency in January of 2026. Number one, and I am hoping that the GAR Forms Committee will address these a little more specifically in this contract paragraph in the mid-year revision. Number one, GAR's opinion not necessarily every broker's opinion. GAR's opinion is that the temporary occupancy is not extended, meaning if a contract had already closed and the seller was in the middle of their temporary occupancy, that did not get extended. The other is the way they count. And let me show you one more document I have included in your handout package. This is from Seth Weissman regarding the states of emergency. I'm not going to read it all to you, but there are examples, and here are questions about the counting of number of days. This is extremely confusing to agents and brokers, and I'm hoping GAR will address this. According to Seth, the state of emergency, the second one actually ran from January 30th through February 6th. For this, he says to count that day as day one. The reason this is confusing is the contract teaches us that for counting purposes, the day of an event, like the binding agreement date or date of a notice, is day 0. So this is extremely confusing, but directly from Seth, this is, again, I'm not going to cover this, but this is included in the handout package that I have for you. All right. Entire agreement. What I have here for you guys that is important for y'all working with well, a couple things. One is this agreement is the sole and entire agreement between the parties and supersedes all prior written and verbal agreements. And additionally, the buyer shall rely upon anything relied upon the buyer, and it is binding upon, if they pass away, their heirs, so forth and so on. There's no outside agreements. All documents are referenced and relied upon. The other thing that is in here, you agents working with investors, this talks about assignment. If you have an investor that wants to assign, becomes a binding buyer on a contract and wants to assign the contract to another buyer, this contract is not assignable in and of itself. It requires, this is the GAR contract, it requires seller's written permission to assign the contract. You agents working with investors, here's how you get that seller's permission. You include special stipulation 611 in that. And then additionally, there are a slew of other amendments and agreements in the GAR contract package regarding assignment. This is important, extension of deadlines. No deadline shall be extended by virtue of it falling on a Saturday, Sunday, or federal holiday, except for closing. This is why this is important, you guys. This is a little crazy thing about the GAR contract. If your due diligence ends on a Sunday, it ends on a Sunday. If your financing contingency period ends on Memorial Day, it ends on Memorial Day. If for whatever reason you have a closing date that ends on a Saturday, Sunday, or federal holiday, it automatically gets extended to the next business day. Why is this important? This is important because, number one, if you failed to look at a calendar while you were writing your contract and you put it on that on a Saturday, then it automatically gets extended to the next day. But look at this. This only happens in the GAR contract. That paragraph about extension of deadlines, no time deadline gets extended except for closing. This is key if you use the 8-day unilateral extension. Why? When is 8 days not really 8 days? Only when the original or amended closing date is a Friday. Why? 8 days from a Friday is what day of the week? It's a Saturday. Well, we just learned we can't close on a Saturday, so closing date automatically gets extended to the next day. Can't close on Sunday. Well, what? Then it gets extended to the next day, Monday. Well, what if Monday's a holiday? Then closing automatically gets extended to the next business day, which would be a Tuesday. This only happens if your original closing date is on a Friday, because 8 days from a Friday is a Saturday. 8 days from any other day of the week would be another day of the week. It could happen if that 8th day falls on a federal holiday. But what's the point of practice for you? Never schedule, if you go binding on the GAR contract, never schedule your closing on a Friday. All right, FERPTA affidavit. If a person is a foreign person, there are tax documents they need to find out. You need to just get them to the closing attorney, let the closing attorney handle that. Nobody is required to use the GAR forms. And also, just so you know, GAR says, regardless of how you go over these forms with your buyers and sellers, if it goes to court, a judge can make a different interpretation. GAR forms may be subject to differing interpretations by our courts other than what the parties may have intended. Our courts may at times strike down or not enforce provisions in our GAR forms as written. Any of the laws pertaining to the contract have to do with the laws of Georgia. No authority to bind, and this is what I keep going over, no broker or affiliated licensee shall have any authority to bind any party to a contract by or amendment by their signature. Agent-to-agent communication, agent-to-agent signatures do not count for anything. Like if you fill out a form and send it and it's not signed, it's not part of the contract. You may only perform the ministerial act of filling in the binding agreement date. Notice of binding agreement date. This is when the binding agreement date is the date when the party who has accepted an offer or counteroffer delivers notice of that acceptance to the party who made the offer in accordance with the notices section. Notice of binding agreement date may be filled in by either party or the broker to the other party. If notice of accurate binding agreement date is delivered, they shall sign it and return it. Here's the issue. You guys, this is really important, this objection to binding agreement date. So what it says is if the buyer and seller, if buyer or seller object to the binding agreement date as entered in the contract, within 1 day of receiving notice, you have to fill in this notice of the objection of the party. This objection shall be resolved by written amendment between buyer and seller executing the binding agreement date confirmation, another GAR form F733. The absence of an agreement on the binding agreement date shall not render it unenforceable. The failure of the party to timely object results in the parties accepting the binding agreement date. Let me give you a brief example. Let's say that you're a buyer's agent and you send a contract and the seller accepts it and they fill in the binding agreement date as today, February 24th. But they don't send it back to you. They don't send notice of it. So we have an accepted contract on the 24th. They don't send it back to you. You don't get notice of acceptance until tomorrow, February 25th. But when they send it back, they have filled in binding agreement date on the purchase and sale agreement. They filled it in on the 24th because that's when the seller signed it, but they don't send it back to you till the 25th. What is the actual binding agreement date of the contract? It says the 24th filled in, but they didn't send it back. Notice of acceptance wasn't until the 25th. What's the actual binding agreement date? Type it in the chat. Yes, the actual binding agreement date is the 25th. The problem is, it says it's the 24th. Y'all need to pay attention to this. So we know what the binding agreement date is, but here's an objection. If you object, you only have 1 day to put that objection out there. You have to use this, say, no, the binding agreement date you have filled in is the 24th, but that's not correct. It is the 25th based on when you sent it back. And you send this and you get it corrected to the 25th. Buyer's agents, in my example, if you do not make this correction, look at this last sentence. Failure of a party to timely object, you have 1 day, will result in the parties accepting the binding agreement date as entered. So if you don't make this objection and get it corrected, then your binding agreement date was the 24th because you didn't make that objection. What does that mean? That means your buyer just lost a day in due diligence. And if you don't keep up with this and they think they have 5 days from the 25th, but you didn't object to this and it was incorrect, it's now 5 days from the 24th, and you send their termination a day too late, you just lost their earnest money. This is really, really important for you guys to be clear and have it in writing what the binding agreement date is. It's not just the dates of signatures. It is notice of acceptance. This is a huge thing. You do not want to lose thousands of dollars for your buyer by having them terminate outside of due diligence when you don't pay attention to the contract and what it says. All right. Let me just, you guys bear with me. I'm going to finish this up and then we'll take a break. I really want to get through the purchase and sale. Let me see how much more do I have to do. 7, 8, 9, 10. No, you know what? Let's take a break. Yeah, I think we'll take a break. So let me, and then we'll come back. We'll finish this and then knock out the rest. So it is 11:19. So let's take a quick break and come back at basically 11:35. So I'm sorry y'all can't see me. I'm going to try and figure out my camera. But let's come back at 11:35. When you come back, then I want you to again type in your name, contact, license number, and contact information. Be back at 11:35, and there is where you can go get the course handouts. See you back in 15 minutes. All right, welcome back from break, everybody. We are going to get started. So let me share my screen. We're going to finish up with the purchase and sale agreement and then cover the financing documents and a couple of other forms. So let me go back, share, and finishing up the purchase and sale agreement. This is where you guys are always looking for the what we used to call broom swept condition, property to be delivered in clean condition, free of trash, garbage, debris, construction materials, pets, personal property, so forth and so on. In 2026, they added the part about construction materials, and firewood shall not be considered debris. Rules for interpreting this agreement. You guys all know this from pre-license. Handwritten controls over pre-printed or typed. Exhibits control over the purchase and sale. Special stipulations control over exhibits. Now, there is a section in here about the amendatory clause paragraph in the FHA and VA loan contingency exhibits, which I'll cover in just a moment. Those control. What that means, it does not matter. A buyer and seller cannot write a special stipulation that overrides the federally regulated amendatory clause. Basically, that means if a buyer's getting an FHA or VA, a government insured loan, and the property does not appraise, the buyer does have the right to terminate the contract and get full refund of earnest money. It doesn't matter if buyer and seller write a special stipulation to the contrary, that verbiage, that protection prevails. There are a couple of stipulations I'll get to in just a minute. And this just says, what about special stipulations? It says if a broker has written any special stipulations, then the party, meaning the buyer seller, confirm that it accurately reflects their intentions. And if a broker answers a question of a buyer, it is doing so based on information provided by the seller rather than the independent knowledge of the broker. Statute of limitations for claims, so forth and so on, is 1 year from the date of claim. Survival of agreement. This is what survives the contract. What does that mean? That means the agreements, promises, consequences that the buyer and the seller agree to. When the contract closes, it closes and everything is done. No more responsibilities after that, other than the provisions that, quote, survive the agreement, survive the closing. And those are outlined here. For example, pay compensation, the warranty of title, all written representations of the seller with respect to the property in the neighborhood, buyer's indemnifications, obligations arising out of inspection, if the property was condemned, attorney's fees, their obligation to prorate ad valorem property taxes, obligations regarding devices and fixtures, liabilities, so forth and so on, or any obligation that they agree shall survive closing or may not be performed or fulfilled after closing. The important thing about this, there's nothing in there about repairs. If a seller has agreed to do repairs, but they don't do them, and you close, first of all, it's not necessarily a buyer's right to terminate if the seller doesn't do them. But on the other hand, after closing, the seller is no longer required to do them, because repairs do not survive closing unless you have brought in this last section that says any obligations the parties agree. Meaning, if you do negotiate for the seller to do repairs, you would want to write in the words, these provisions or these repairs shall survive closing. Then there is a legal obligation for the seller to perform even after the closing of the transaction. That's what survival means. It's very important. This is all the definitions of banking days, binding agreement date. One thing I want to point out to you, broker, whenever the GAR purchase and sale agreement says broker, it also means you, the affiliated licensee, and the company itself. Business day, client, closing. This is important. This is what a closing is. How do you know when you've closed? Well, here's how you know when you have closed is based on this definition. And bottom line is, it is when everything has been done, everything signed, everything recorded, but most importantly, when the funds have transferred. So you are officially closed when all of the funds have transferred. Definitions of customer compensation, as I mentioned earlier, by default, your public people with whom you work are customers, unless they have signed a brokerage agreement, which makes them calendars. Here, you guys repeatedly hear me say a deadline goes to 11:59 p.m. Why do I say that? Don't trust me. You guys look for the evidence. Here is the evidence. It is defined in the contract. Here's what a day is: a full calendar day ending at 11:59 p.m., except as provided for elsewhere. Here's what a material relationship is. Here is the warning about cyber fraud. Make sure your buyers and sellers know not to blindly trust any wire instructions they get via email. It is our emails getting hacked, lenders' emails getting hacked, closing attorneys getting hacked, and now text messages too. They need to verify. Go to Google. Don't rely on any instructions that come in that email or phone numbers or emails. They need to go to the Google and look up that closing attorney and get third-party verification. I've already mentioned there is a ton of bad guys impersonating sellers. Y'all be extremely leery. If you get a call from someone that says they want to sell vacant land and you do not meet them in person, there is a high likelihood that it is fraud. And limit a broker's liability. Our liability, buyers and sellers acknowledge that brokers have no compensation paid, and if no compensation paid, $100. And then this is where you outline the label the exhibits that are part of the purchase and sale agreement and the special stipulations. Again, these are my notes on the 8-day unilateral. GAR added this last year that if the party with whom you are working is an entity, then this is it instructing them how to sign the contract. This is how they sign the contract, their name, and it must include the capacity in which they're signing, such as trustee, general partner, manager, so forth and so on. You do not need an email address or a phone number for your public person if and only if you are representing them as a client. Again, as I've already talked about, if you're working with them as a customer, you absolutely need either their email address or their full-blown address for purposes of notice. Here's your information. You need your license number and your firm's license number to stay in compliance with license law. If you are on a team, let's say you are a buyer's agent on a team, you need the license number of the team leader and your license number. So if you're a buyer's agent for a team, you need whoever that team captain is or team leader and yours. And here is where the person receiving the accepted contract fills in the binding agreement date. Woo! All right, let's move on to let me just quickly cover the counter offer. I'm not going to belabor this, but I just want to cover this. I need to get to the financing forms. This is the counter offer. I just want to point out to you, everybody has an issue. If the buyer writes an offer and the seller writes a counter offer and it gets signed by the buyer, does the seller go back and initial the exhibits? And the answer is no. No, and it is spelled out here. This talks about all previous offers and counter offers are rejected. The original offer is incorporated by reference. Here's where it says, only this counter offer needs to be signed to create a legally binding agreement, even though other parts, including exhibits, have not been signed or initialed. What about our lenders? Guess what they want? Yes, they want initials on those financing exhibits. If that is the case, you are going to do a clean copy. And here are the instructions for doing a clean copy, including the special stipulation to include. Here's the date you put on the clean copy. And in the counter offer in and of itself, if let's say you're only countering closing costs, everything else is the same. Well, you don't put NA, not applicable. Of course it's applicable. It's important. You put NC, meaning no change. So purchase price, NC, no change from the original offer. The only thing in my example we would be countering is the closing cost. You'd put a change, the countered amount there. Closing date, NC, no change. It's all spelled out for you here. So that's a counter offer. Okay, let's talk about these loans. This is the conventional loan contingency exhibit. I'm going to cover the loan exhibits. Bear with me. I'm going to quickly go over the closing attorney as holder of earnest money and the TNR after this. But the majority of time, we go till 12:30. So we will get finished. All right. Again, you fill in the offer date and the property address. This loan information is important. What this is, however, this is not necessarily the loan the buyer has to get. You guys, the way to think about these loan financing contingency exhibits is how to protect a buyer's earnest money if they can't convince a lender to lend them the money. What do you mean, Dana? Here's what I mean. You fill out this information, and you have to fill out this information. Buyers shall promptly apply for and in good faith seek to obtain a conventional loan described below and fulfill their obligations hereunder, meaning with respect to this exhibit, with all of this. So you fill in the loan amount, percent of, you guys know how to fill this out. Use of, I'm going to come back to that in a minute, so bear with me. There is a place to fill in an approved lender. That is only important for loan denial letters. Now, a seller's agent is probably going to want to see that the buyer has applied for a loan with the lender. You can always attach a loan pre-approval letter without identifying a lender on this exhibit, because it says nothing herein shall require the buyer to obtain their mortgage financing from an approved lender. Then why do you need it here? I'll show you in a minute. Length of the financing contingency. You fill in the blank. The financing contingency is so many days from binding agreement date. This is the time frame for a buyer, if they cannot convince a lender to lend them the money, to send notice of termination. We also, in the conventional exhibit, have an appraisal contingency time frame. This is not a termination time frame. The time frame for this time frame, so many days from binding agreement date, not for a buyer to terminate if you get a low appraisal. This is for a buyer to send the seller an amendment, giving the seller the opportunity to sell it to the buyer for the lower appraised price. If you buyer's agents, if you're under the conventional, actually the other two also, and you get a low appraisal, and you feel like, oh my gosh, we have a 21-day appraisal contingency, it's day 20, I need to send a termination. If you do that, you've just defaulted the buyer and lost them the earnest money. That's why I have this financing contingency, which is an assessment of the buyer's ability to pay back the lender, and an appraisal contingency, which is an assessment if the property is going to be enough collateral that if the buyer doesn't pay back the lender and the lender gets the house back, can they sell it and cover what they owed, what they lent the buyer? Two completely different things being evaluated. But this is a termination time frame for the buyer. The financing contingency, appraisal contingency is a time frame to send the seller an amendment. But let's get back to the loan part again. Buyer may apply for a different loan, different from what was described up here. However, the denial of another loan shall not be the basis for the buyer to terminate this agreement. Meaning, you put information here with a certain down payment, certain number of years, and a certain interest rate. Lender says, hey, I've got a better deal for you. The buyer applies for a different loan than what they described here. They get denied. You get a loan denial letter that describes any other loan than what here. They are not protected on this. They will terminate, but they won't get their earnest money back. The loan denial letter has to be a denial of this loan that is described here. That's why that's important. Additionally, buyer does not have the right to apply for an FHA, VA, or USDA loan unless the parties agree via amendment to add in the FHA, VA, or USDA loan contingency exhibit and remove this conventional. And a seller doesn't have to agree to that. Once a buyer, regardless if it's an approved lender up here or another lender, so this can be blank is what I'm telling you. You do not need to fill this in. This can be blank. Once a buyer has selected a lender with whom they're going to proceed, they've sent their notice of intent to proceed. The buyer is required, a lot of agents miss this, to send the name and contact information of the loan originator to the seller. Now, does the seller have termination rights if they don't do it? No, but buyers agents, you guys need to keep the seller informed. Now, this next page, let's look at what is the financing contingency. Again, that is the time frame that the buyer has to convince a lender to lend them the money. And if they're not able to, then they have to terminate prior to that time frame, and they have to prove it. You have to prove it with a loan denial letter from the lender, and in 26 they added stating the basis for the loan denial. So you have to terminate within this time frame. You have to prove it with a loan denial letter that can come 7 days after you terminate. So the 7 days can come after this time frame, but it's 7 days from the date you sent notice of termination. And if there was an approved lender named, that loan denial letter must come from that lender. And we just read, and it must be a denial of that loan as described. So if there's not an approved lender labeled, identified on that first page, then a loan denial letter can come from any lender licensed to do business in Georgia. Now, what about the loan denial letter? This describes the loan denial letter. Loan denial letter must state the basis for the loan denial and may not solely be based on one of the more of the following. In other words, you get the loan denial letter from the lender and it says, we denied the loan because the buyer doesn't have enough money of their own for their down payment and everything else. Yes, they won't get their loan. They'll have to terminate the contract, but they will also lose their earnest money. If any of these reasons here are the sole reason for the loan denial, the buyer's earnest money is not protected. So no money, lacking sufficient funds other than their own. They haven't sold or leased real property unless that contingency was part of this contract. They did not in a timely fashion, provide the lender with all information required. They made purchases that adversely affected their debt to income ratio. They went out to Rooms to Go and did same as cash. Well, guess what? It still hits their credit report. Their credit scores are no longer in line. They get denied the loan. They'll get denied the loan. They'll terminate the contract and they'll lose their earnest money if that's the sole reason on the loan denial letter. So all of these reasons, not appraising for purchase price, lender not having completed underwriting the loan request, that can't be on the loan denial letter. The sole reason, they'll lose their earnest money. Buyer may terminate this agreement without penalty if they've done so without all of that. Now, you guys, this was last year. This was added last year. In all of your financing contingency exhibits, there is a third built-in contingency. First built-in contingency is the financing contingency. A buyer's having to convince a lender to lend them money. Second built-in contingency to all your financing exhibits is an appraisal contingency. If the lender says, yep, I think this person's a good bet, I'm going to lend them money and I bet they'll pay me back over 30 years or 15 years or whatever. However, lenders are like, they're very cautious. In case I made a bad decision and I made a bad bet and that person does not pay me back, then I get the property back and I have to sell the property and recover the money I lent out so that I am not out any money. So not only does a lender assess the buyer's ability to pay them back the loan, but in case I make a bad decision there, if I have to sell the property, will I recoup enough money to pay myself back? So the appraisal is an assessment of the value of the property. A financing contingency is an assessment of the person. Two completely separate things being evaluated. Those two contingencies are built in, and now there is a third built-in contingency on these forms. If the property is a condo or is an attached residence and subject to a master fire and casualty insurance policy or a master insurance policy. There's a lot of issues going on with these in condos right now. I don't have time to cover everything, but basically the premiums are now being, instead of the HOAs paying them, The premiums are now being sent to the actual homeowners are paying them. And it is based on the numbers. A lot of lenders are saying, nope, this is not a good risk for my buyer or for the property. So this is a third built-in contingency that if a lender does not deem give the property approval, if they don't like what's in this master insurance policy, buyers shall have the right to terminate this agreement without penalty and receive full refund of earnest money if they get a letter from the lender stating inability to obtain project approval is what's preventing the mortgage loan from being made. No time frame here, so it goes through day of closing. Again, a third built-in contingency. Now we go past the financing contingency time frame. The seller now has the right to say, okay, buyer, you didn't terminate, no more protection under the financing contingency. Now you have to provide me with evidence of your ability to close, which it says here is basically a loan commitment letter from the lender that states conditions. There's timeframes built in for here. And if the buyer does not provide that, again, there's timeframes, and then the seller does have the right to terminate. Additionally, this does authorize the buyer to release, basically it says lender is to release information to both agents and the sellers if they ask. Buyer's giving them permission. They don't always do that, but the buyer's giving them permission there. Here's the appraisal contingency. Again, remember I told you this time frame is not a termination. This is a time frame, so many days from binding agreement date, for the buyer to send the seller an amendment asking them to sell them the house at the lower price. Why did you say that, Dana? Because the instructions tell me. Here are the instructions. This is if the property appraises for less than contract price by no later than 11:59 p.m. on that day. The buyer has to provide the seller with this amendment to purchase price F713 along with a copy of the appraisal. And then here are all the time frames built in. The seller has 3 days to accept it, reject it, or negotiate, and then the buyer has 3 days. If you don't come to terms, the buyer then has 3 days to terminate. So there are termination rights upon a low appraisal. It's just not immediate. It's only if the seller does not agree to sell it at that lower price. If the seller does agree to sell it at the lower appraised price, buyer is obligated to go to closing. Again, this is all where it's spelled out what those time frames are. Now, let me cover FHA and VA and then the no financing. This is if a buyer is getting an FHA insured loan. All the same stuff I just mentioned is all the same. That's why I have C notes on the conventional. All of this is all the same. Here are the differences. If a buyer's getting an FHA insured loan, well, actually, let me back up here. You see you do see a time frame for the financing contingency, no time frame for that appraisal contingency. If a buyer is getting an FHA or a VA insured loan, the appraisal contingency, how we think of it, is under the amendatory clause. This addresses appraisal. There's no date, so it goes through 11:59 p.m. day of closing. But here's what happens. A buyer getting a government insured loan, their earnest money is protected if it appraises for less than in the FHA. You have to put in the amount. Buyer shall not be obligated to complete the purchase or incur any penalty by forfeiture of earnest money if the property does not appraise for less than. Do not leave that blank. Do not write in sale price. If there's a fill in the blank that calls for a dollar sign, you need to fill in the amount. Now, even though a buyer has termination rights upon a low appraisal, it's not immediate. It's just like in the conventional. Agreement to seek amendment to purchase price prior to termination. If you get a low appraisal, as soon as you get it, the buyer has within 3 days of publication date of basically what the appraisal is, to provide the seller with a copy of written statement along with amendment to the purchase price, just like the process we went through under the conventional loan exhibit. You have to give the seller the opportunity to sell to the buyer at the lower appraised price. Timeframes are built in here. And then if the seller does not agree to sell it to the FHA buyer for that lower price, the buyer then has 3 days to terminate and will get their earnest money back. For an FHA insured buyer, you have to fill in the amount of the FHA premium, mortgage premium, and get that from your lender, and in full and closing or added into the loan amount and finance. That's what most buyers do. The seller on an FHA insured buyer has to pay the tax service fee, and either it is included or is not in addition to any closing costs that they paid. And then repairs. If the FHA lender says this house needs repairs in order for it to appraise for the price, then you negotiate here who, buyer or seller, is going to pay for the repairs as long as they don't exceed this amount of money. You agree to that up front. Let's say they agreed to $3,000, $5,000. There's not a set amount. It depends on the price of the house. I mean, if you're selling a $300,000 house, the amount of repairs might be different than a $100,000 house, if there is such a thing anymore, right? Well, what happens if the repairs are more than what was negotiated up front? That is all spelled out here. Again, go to the instructions. If the anticipated costs exceed the amount listed above, here's what you do. Here's what the timeframes are. Here are termination rights. Well, the seller is obligated to go get a third-party estimate of how much those repairs are, and you send it to the buyer and you guys negotiate. So let's say if this said seller to pay $1,000 and the actual repairs are $3,000. We have to figure out who's going to pay that additional $2,000. Seller gets an estimate, seller and buyer negotiate. Here are the time frames. The seller is still obligated to pay that initial amount here, or whoever was here. It's just that overage. If buyer and seller don't agree, guess what? Contract automatically terminates without penalty to the buyer. Those time frames are spelled out there. Additionally, on the government insured loans, there might be an obligation to connect it to public sewer if it's available. Who's paying that and how much? What happens if the cost is more? And arm's length transaction. That means there's no relationship between the buyer or the seller. That has to be disclosed on an FHA or VA loan. So that's an FHA loan. VA loan, similar to the conventional and the FHA. One exception, 2 exceptions. A mandatory clause. There is no fill in the blank for the dollar amount. This basically means sale price. If the property must appraise for sale price. If not, the buyer has termination rights, but they're not immediate. You first have to give the seller the option to sell to the buyer at the lower appraised value. Here are the time frames and the amendments to send. If not, the buyer may terminate and will get the earnest money back. Again, no time frame, so it goes through day of closing. VA funding fee. Get with your VA lender. They will know what these funding fees are when the buyer's paying it. Same thing with repairs that we talked about in the FHA. The seller is required to pay how much and what if it's more. And then here is the biggest difference, termite letter. In a VA insured loan, a termite letter is required, termite clearance letter dated within 90 days of closing. Who's paying for the initial letter, buyer or seller? That gets negotiated. However, if there was active infestation and it gets corrected and there's a reinspection, the seller is required to pay for any reinspection fees. Other than that, that is the same as the other financing exhibits. Let me briefly touch on the no financing contingency exhibit. We used to call this the all cash exhibit. This is if a buyer is paying all cash, actual cash, or they are going for a loan, but they're not making their deal contingent upon it. Look, I know I can get a loan. I've got awesome credit. I have no worries whatsoever a lender is going to lend me the money. However, I'm still disclosing to you, seller, I am getting a loan. I'm just not giving myself the right to terminate the contract and get earnest money back if I don't get the loan, because I know I'm going to get the loan. So it is still getting financed, but there's no contingency upon that. With that, there is no right to unilaterally extend the closing for 8 days based on any mortgage delay. This is verification of funds or proof of funds, and this is where you negotiate how many days from binding agreement date that the buyer has to provide proof of funds to the seller. Seller's right to terminate if they don't do that. There is an appraisal contingency that they can negotiate. And again, that same issue with if it's a condo or attached housing, contingent upon this master insurance policy. All right. Let me show you. Closing attorney. If buyer and seller negotiate to have the closing attorney as the holder of the earnest money. And there are 2 forms we need. One is the F510. The other is the F511. The F510, which is this form I'm going over now, this is an exhibit. What does that mean? That means it's part of the purchase and sale agreement. So you reference this in the purchase and sale as an exhibit. You fill in the offer date and the property address. This is saying buyer and seller are negotiating that the closing attorney is the holder of the earnest money. But it says, it even tells us up here, closing attorney must still consent to serve as holder by using F511. This is the closing attorney named shall be the holder, and more below. Buyer, you buyer's agents, if you guys decide that the closing attorney is the holder, the buyer has the burden of getting the contract to the closing attorney as holder within 2 business days from the binding agreement date and presenting them with the F511 to sign. The closing attorney then has 5 business days of receiving the entire contract to sign and agree to be the holder of the earnest money. This is what the closing attorney does as holder, which we covered in the purchase and sale. Make the deposit, send notice if it's not honored. If it terminates, disperse the earnest money. Do the 10-day letter potentially if they don't agree on the termination and release, so forth and so on. However, what happens if a closing attorney says, no, I'm not going to do it? Not every closing attorney will agree to hold the earnest money. Some won't do it because they don't want to mess with it. Some won't do it if the earnest money isn't above a certain dollar value. Some won't do it until they get the earnest money. Some just won't do it. If the closing attorney does not sign that F511 within 5 business days of getting the contract, which is 2 business days of the binding agreement date, then the alternate holder immediately becomes the holder of the earnest money. There is a fill in the blank there to put in one of the brokers. If that is left blank, it automatically becomes the buyer's broker. You buyer's brokers on here, you actual qualifying and managing brokers here on this class, y'all need to pay attention to this. You need to mark in your calendar when you get a binding contract from one of your agents. If you are named as the alternate holder, you need to put in your calendar when to expect the F511. If you do not receive the F511 in that time, guess what? You are now the holder of the earnest money. If you are not in possession of the earnest money itself, because you're now the holder, you are now responsible for sending the notice to the parties. So you actual qualifying brokers out here, y'all need to pay attention if you are named as the alternate holder. Now, you guys, this is so important, and a lot of agents don't know this. If it's an all cash transaction, you really do not want the closing attorney to be the holder of the earnest money. Why? Because nothing's an issue if it's an issue. If it's an all cash transaction, doesn't close, buyer and seller do a termination and release, but they do not agree on who gets the earnest money. They don't sign the release portion. A broker can do a 10-day letter and disperse the earnest money. All cash transaction, don't agree on a TNR. The closing attorney as holder cannot do a 10-day letter. It has to go to court. You have just engaged your public people in a lawsuit. Don't do it. Think twice about an all cash transaction with the closing attorney as holder. And then you name, don't leave this blank, the closing attorney, so forth and so on. So that's an exhibit. So that's part of the contract. Then the buyer has to get the closing attorney this form. This is not part of the contract. It's not an exhibit. It is only an agreement where the closing attorney says what they have to do. They have to agree within 5 days of getting the contract. If not, the alternate holder, you need to fill out, sorry, that's spelled incorrectly, the buyers and sellers contact information, and then only the closing attorney signs. So your brokers need this, the buyers and sellers need this, but it is not part of the contract, and the buyers and sellers don't sign it. What if it's seller financed using an attorney? Same thing, it doesn't matter who the lender is. The closing attorney only using an attorney for, yeah, if the buyer and the seller agree to that, then they agree to that. All right. Good question. Let me cover termination. So if you're one of the parties, typically the buyer, there are a few seller termination rights as we've covered, but basically once you listing agents, once a closing, once the seller goes under contract, there are very few termination rights for the seller. The majority of the termination rights in a purchase and sale agreement are for the buyer. So typically it is the buyer terminating. However, as I mentioned, there are some times when a seller can terminate. Unilateral means only one signature, and there are two parts. GAR has put two separate contract issues on one form, and they put it in boxes because it's two separate issues. One is the unilateral notice to terminate. Buyer or seller is terminating. Why? Well, either because they're sending notice of termination before the end of their due diligence period. You guys, you don't need an explanation. You don't need to say because it needs this repair, or because they can't get their loan, or because blah, blah, blah. It doesn't matter. The buyer may terminate for any or no reason. So you just put because they're doing so under due diligence. No further explanation needed. Or failure of the following contingency. For example, you would put financing contingency, appraisal contingency, whatever contingency. Or if one of the parties default under by buyer or seller, and then you would put, for example, I don't know, buyer default, you'd mark buyer and you would put terminating after expiration of due diligence period. That would be an example. Other lawful reason. I have a lot of times people ask me, what would that be? I have an example. Seller's right to terminate because buyer is unable to provide evidence of ability to close per paragraphs 10 and 11 of conventional financing contingency exhibit A or whatever. That's not really a contingency. In that part where there is a seller right to terminate if the buyer doesn't provide them evidence, it's not a contingency. It's just something spelled out in the contract. So that would be other lawful reason. And then you only need the signature of whichever party is terminating. Then, and once it's terminated, it's terminated. Once it's terminated, the disbursement of the earnest money, if they agree or disagree, doesn't mean anything about the termination. It's terminated. Seller, you put the house back on the market and go sell it to somebody else. The disbursement and the agreement, what happens to the earnest money, is a separate contract issue. So you only need one signature to terminate, but you do need both parties agreeing to the disbursement of the earnest money. So this is how they're proposing, whichever party's terminating, this is what they want done with the earnest money. Amount of earnest money, name, and labeled party. For example, $3,000 to buyer Dana Sparks. Your holders, it'd be nice if you gave us their address, but definitely the party. Now, as I mentioned before, if there's an issue or the closing attorney is going to have to send, or I'm sorry, the holder is going to send it to court, the parties, or even if there's not an issue, whatever, the parties themselves can divide up the earnest money. So for example, you could put buyer to receive $1,500 and seller to receive $1,500. Buyer and seller can decide whatever they want. The holder, we have to treat that amount of money as one big pile of money and can't divide it ourselves. And you need both buyer and seller. The other thing I want to talk about, what happens if a buyer terminates, let's say they terminate due diligence before they were even required to send the earnest money. So let's say buyer was to remit the earnest money to the holder within 5 days of binding agreement date, but they end up terminating on day 2. You still have to, I have here, if earnest money is addressed in the creation of a contract, it must also be addressed in the termination of a contract. If the termination is before they were required to admit, you can't leave this blank. Y'all, you still have to put in what happens to the earnest money. Here's what you write in. Buyer to retain earnest money, not yet remitted, per paragraph A7B of purchase and sale agreement. Again, you have to address the earnest money, regardless of where it is in physicality. All right, one more form, and then we're done. So let's say a buyer and a seller have terminated a contract, but they change their mind. They decide they want to reinstate the contract. You cannot amend a dead contract. Once it's terminated, it is terminated. You cannot do an amendment to a terminated contract. So what do? GAR has this form, agreement to reinstate the contract. And you fill in the buyer and the seller, you reference the property and the binding agreement date, and it says, buyer and seller mutually agree to reinstate the last fully agreed upon version of the above referenced agreement such that it shall be, again, legally enforceable contract binding upon the parties as if it had never been terminated. All of the terms, conditions, and timeframes set forth, including binding agreement date, shall remain in full force and effect except for any changes. So, for example, let's say, let me go through this and then I'll give you an example. If earnest money has been dispersed, the buyer is going to have to pay it again. If earnest money has not been dispersed, it just stays on hold with the holder. And this offer to reinstate the agreement expires at whatever date and time, and then you sign it. Let me give you an example. Let's say you have an appraisal contingency. You sent the amendment, the buyer sent the amendment to the seller to reduce the sale price. The seller said no. The parties have sent an amendment to what's the word I'm looking for? They sent it to the lender to dispute the appraisal. They want an appraisal review. The appraisal review has not come back yet. But you buyer's agents, you need to protect the buyer. So you terminate based on the appraisal contingency, because you've already sent the seller that they said no, you have to terminate before the end of that time frame to protect the buyer's earnest money. You terminate the contract because you're really waiting on an appraisal review, but you protected the buyer's earnest money. 2 days later, you get notice from the lender that the appraisal got reviewed and it came back up to sale price, so everybody's good to go. At that point, you would reinstate the contract. So that is a really good use of when you've terminated but went back. It's just to protect the earnest money. Now, an example of what you would done here, let's say they terminated for whatever reason, they decide to reinstate the contract, but you've passed a contingency time frame and you want to extend that. You could extend a time frame for something that's passed or hasn't passed. So is it okay to write NA if earnest money has not yet been submitted? No, you wouldn't put NA. You still, if earnest money is addressed in the creation of a contract, you still have to address it regardless of where it is. So typically I don't see them being terminated that quickly and reinstated, but you would put what I put in that language on the TNR, you would put that there. But again, this is a relatively new form. It's only been in existence for a few years because again, you think, well, we'll just amend it. You can't amend it. And I think we made it, you guys. So let me show you my last slide. And I just want to thank everybody. I do want you to remember to confirm all your contract questions with your broker. There are additional courses. CE credits, again, this does satisfy broker CE within 3 to 5 business days. If you are leaving, you are more than welcome to leave. Please type in again your name, license number, contact information in the chat. I will pop up some of those additional tip sheets where the handouts are. I reference it. Some of you guys are familiar, but I do have a YouTube channel where I cover all of this stuff really thoroughly in depth. My target audience are all real estate agents in the state of Georgia. It's real estate made crystal clear. I thank you guys so much for your time. I sincerely hope that I achieved my goals, that the time went by quickly. The CE credit is just a bonus and you learn something extremely valuable, and that I did honor and shine. God was a vessel for God's light to you and a blessing to you in your time here, and so that you may in turn bless your family and your public with your real estate license. So I will stay on if anybody has any questions. The chat is going by very quickly. So feel free to unmute yourself and ask any questions. And I thank you guys so much. We will be teaching, thank you. We will be teaching another class later on in the year on the brokerage agreements and customer agreements, going in depth through those. So stay tuned for that later on in the year. Any questions? Thank you. Yes, sir.
You still have my information, Paul Macy?
Yes, sir, I do.
Yeah, I haven't learned this yet, this virtual place.
Well,
okay.
We've got you taken care of, sir. I did see you were on class the whole time, and I hope you enjoyed the format and the class.
Very much so. Thank you.
My pleasure.
All right.
Thanks,
you.
Dana. This was great. Nice seeing you again. It's Monifa.
How are you? Oh my gosh. So good to see you.
How you?
We're talking about these weather events and the automatic stay due to state of emergency. When there's a major catastrophic weather event, typically the power goes out. And when the power goes out, typically the internet goes out. There's no way to get contract signatures. So you can't close. The closing attorney's offices are closed. You can't drive on the roads. No, there's no power. So you can't sign anything. You can't do business. But then it's like, okay, if I don't sign an extension, I get past my contingency time frame. That's not fair because I didn't physically have any ability to negotiate an extension of that. A closing attorney can't, so who's in default? Who's losing earnest money? So theoretically, putting these automatic extensions into place for the number of days the governor has declared a state of emergency for that county, not to exceed 8 days, makes sense, because you can't, you just physically have no internet, no power, no whatever. So it makes sense for protection of everybody. And basically the contract just goes into a standstill, gets frozen in time, and then gets reinstated, but basically for those number of days.
So
It just so happened that the first state of emergency was for 8 days. That's a long time. Then what was unusual is there was a back-to-back state of emergency for another 8 days. That is an extremely long time frame. Now, the buyer and seller who didn't lose energy, or now that we're out, we all have energy, it's a gorgeous day out, they can do an amendment that says all parties agree closing date will be blah, blah, blah. All parties agree the end of the financing contingency timeframe will be blah, blah, blah. They can do that now if they choose to. I guarantee you there's going to be, I've had some of my agents email me, well, am I extended? When's the new closing date? And I'm telling them what I'm telling everybody, that yes, it was an automatic extension for 16 days. There's a lot that don't understand it or don't know how to deal with it. I suggest you do get everybody on the same page. Like I said, especially with the closing. Well, this is the first time this contract provision has been in place where there's been a state of emergency declared. This is new to everybody, all the closing attorneys, all the lenders, all the brokers, even GAR, because, so you need to get on the same, okay, closing attorney, when do you have a schedule now? Let's get everybody on the same page. For example, with Seth, and his thing that his Q&A came about because there were a couple brokers that I was in touch with during this time frame, and we had questions like the temporary occupancy. The deal had already closed, was in temporary occupancy. The question is, does that time frame also get extended? My broker answer was yes, because same thing, no electricity, no whatever. The seller's not going to be able to hire movers during that time frame. But Seth came back and said no, that temporary occupancy time frame does not get extended because the contract had already closed. Well, that doesn't make sense to me as a broker, but I'm not an attorney. I'm not on the GAR Forms committee. The big issue to me is the counting, because in the purchase and sale agreement, I will show you, Seth says, and he puts it, that's why I put that Q&A out there. Seth says that, I'm going to show you where it has it in this purchase and sale agreement. It's in the definitions. I'm pulling it up and then I'll share my screen in a second. Seth says that the day of emergency. Okay, here we go. Let me share my screen. Let me show you this. This is what I really hope that GAR defines this in the contract in the mid-year revision. Okay, I am on, you guys will see it in just a second. I'm on the purchase and sale agreement, F201. In paragraph C5, under the definitions, day, here it is, day, right here. For the purposes of this agreement, the term day shall mean a full calendar day ending at 11:59 p.m., except as may be provided elsewhere herein. For purposes of counting days for determining deadlines, the specific date referenced as either the binding agreement date or the date from which the deadline shall be counted will be day 0. Binding agreement date is day 0. If you send a notice, the date of that notice is day 0. It tells us how to count. Then Seth has in his, where is it? In his Q&A, how do I count? The state of emergency runs from January 30th, day 1 through February 6th. That means it's 8 days. Well, that goes exactly opposite of how GAR tells us to count. The day of the
Right.
event, January 30th, would be day 0 according to how the contract instructs us to account. So
Mhm.
that I hope is, so really to me, it should have been a 14-day extension, but not according, and I'm not GAR, I'm not Seth, I'm not.
Mhm,
So
mhm.
I,
So I definitely agree on the extension for the weather, but what I was talking about was like, you know, if one person has the right to extend unilaterally and then the next person has the right to unilaterally
oh,
extend
I'm
again,
sorry.
it's like that's okay. That's like 18, I mean yeah, that's like
16 days.
16 days. Yeah.
Potentially, I know.
That's a
I
long
agree with
time.
that, Monifa. That got changed this year because it used to be you could only use it one
I
time
remember,
per
I know.
contract
Yeah.
because you can extend. Now it is a potential 8 days for one person being held against their will, and then an additional 8 days for the other person against their will. That is. I agree. I am not on the GAR Forms Committee, so I don't know. I don't
Yeah.
know. I don't know. I totally agree. That is a very interesting
Yeah, that's kind of long, but
change.
well, maybe I'll volunteer.
There you go. They also take suggestions. You can reach out to the GAR Forms
Oh,
Committee and suggest suggestions to the committee for changes mid-year or next year.
okay. All right. Thanks, Dana.
You're welcome. Anybody else? All right.
Hi, Dana. Where they stated that the due diligence date, once it falls on the weekend, it ends on the weekends.
Mhm.
My question was, but could we, in the special steps, write something in the special steps in reference to that?
Absolutely. If buyer and seller agree to it, you can say, I've seen contracts where it says all contingency timeframe days are banking days rather than calendar days, or
Okay.
you can specify just, uh, uh, due diligence period shall be banking days rather than calendar days. Yeah, if buyer and seller agree to that, you can absolutely do that.
All right, so that's what I needed clarification on, that it could be negotiated in the special steps.
Yeah, buyer and seller can negotiate anything in special steps other than something that's law. For example, they cannot negotiate a special stipulation during the extremely fast market we had where properties were selling for gazillions of dollars over list price with 20 backup offers and things like that. If a buyer was getting an FHA or VA insured loan, we saw all kinds of special steps that said basically buyer to go through with contract regardless of appraisal value. Well, and a buyer's getting an FHA loan. Well, or buyer shall not terminate based on appraisal value. Basically, no appraisal contingency. And a buyer was getting an FHA loan. It didn't matter if the buyer and seller agreed to that in a special stipulation. In that situation, you cannot write a special stip for something that is a law or federal regulation. So you can't, for that they can't agree. You can't agree to that, but they can't agree to anything that's not illegal.
Okay.
There's a lot of buyers and sellers that don't like the 8-day unilateral extension. They agree that provision shall not be part of this contract. They just strike, that's not law. It's just a GAR contract provision. So they write in there that no party has the right to unilaterally extend the contract. They just take out that whole sentence. Does that
Yeah.
help?
Yes, it helps a lot. Thank you.
You're welcome. Good talking to you.
You
Anybody
too.
else?
Let's see if
All
you-
right, everybody. Thank
Okay.
you guys so much. And I appreciate your time and your attention. And I look forward to seeing you in another class. Bye, everybody.